Anyway, welcome to the first session. I hope it's not going to be a bit of, after the Lord Mayor's show, we opened with such a bang this morning. But this is on global connectedness. It's a massive topic, of course, and one that literally encompasses the whole world. But we're going to focus down on a couple of specific areas today. Susie talked about a number of themes that had emerged from the project. And one of them that she particularly paid attention to was New Zealand's choice as a small, isolated country with its own jurisprudence of going it alone or adopting other countries' ideas. And that, while it won't be the explicit topic that we're discussing today, will, I think, underlie much of the commentary that we hear. And it goes back to the start of the project, when I remember at the first meeting of the Law Foundation where they called for suggestions for ideas that their resources could be spent on. My mind went back to some work that we'd done at NZIR jointly with David Goddard on this very question of how New Zealand should approach its regulatory style and to what extent it should take account of the specifics of New Zealand and to what extent it should take advantage of the rest of the world's experiences and how they pan through. And I don't think it's unfair to say to David, neither of us thought we'd completely cracked the problem at that stage. And so it was wide open for a larger project, and that was put forward, and after a lot of massaging and a tender process and so on, it became the project you see in front of you today. So one of the issues, of course, of global connectedness is just that it's complex, difficult, changing all the time, and so on. But today we're going to consider two particular aspects. The first one to do with what's involved when a country joins an international grouping. There are obviously advantages, or the country, one can assume if they're at least vaguely rational, although after the talk this morning, who knows? Clearly nobody's in control. But what does it get out of it and what does it give up? And then secondly, why would any country want to distinguish between the nationality of the owners of certain of its real property and thus have different processes applying to purchasing techniques? Now, we've got three presenters for these, and I just noticed that they happen to span the three different collaborative groups that we've worked with in this project. So we've got Meredith here playing for the academics, we've got Chris playing for the economists, and we've got Daniel playing for the practitioners. And I won't introduce them because, apart from the fact that most of you will know the three of them, their bios are in the back of the material, and if you want to know anything else about them, you can just ask them. So I'll just mention that Meredith and Chris, who kick off first, have got 15 minutes each, and Daniel has 20, and if they start to get to the end of that time, I'm going to wave a piece of paper. They've all assured me that they will not go over time, so we can have a bit of monitoring and sanctioning later on in the show. Over to you, Meredith.
Great. Thank you very much, John, and thanks to all of you for being here today. As John said, Chris and I are going to be sort of jointly presenting the paper on the web of trade agreements and alliances and impact on regulatory autonomy. But we had two other co-authors, John and Susie, and so if you ask difficult questions, we may decide to punt it to them. But feel free to ask away. We'll do our best. So I'm going to begin by introducing kind of the context and the conceptual framework for the paper we wrote, as well as introducing the illustrative example that we use in the paper. And then Chris will explain sort of the comparative methodology that was used to study the example and present the analysis and the conclusions of that study. So the context for this research, as the title suggests, is the web of trade agreements. Not only is New Zealand a member of the WTO and has undertaken commitments under that agreement, but also New Zealand, of course, is a party to a number of free trade agreements which have their own commitments. And more recently, New Zealand has become a part of two different sort of more complex trade negotiations, one of which is the Trans-Pacific Partnership, which I think everyone is familiar with, And the second is what sort of used to be called ASEAN plus 6, but these days is being called the RCEP, or the Regional Comprehensive Economic Partnership. And RCEP, or ASEAN plus 6, is the ASEAN countries plus Australia, New Zealand, Japan, China, South Korea, and India. And both of these negotiations are ongoing, although RCEP has only just gotten started. So there's not much that we know about that yet, other than that it has started. Okay. So these new trade agreement negotiations put New Zealand in the position of needing to assess anew the costs and benefits of taking on new trade commitments, and also of what it is New Zealand's trying to achieve offensively in these agreements. In making this assessment, we felt in our paper that it's important to keep in mind that terms that are achieved in these kind of plurilateral agreements, I'll say, so the TPP and the RCEP both include over 10 parties. So it's not a bilateral FTA. It's not as big as the WTO, but it's certainly not a bilateral arrangement. So we're calling them plurilateral agreements. And what we think it's important to keep in mind is, particularly in negotiating a plurilateral agreement as opposed to just a bilateral one, there may be implications to the types of terms a party agrees to that are going to extend beyond just that agreement. In other words, if you have 16 countries in ASEAN plus 6, or 12 countries in the TPP, now that Japan seems to be on board, or 11 if you think they're not, if they all agree to a particular provision, the chances that that is going to spread and be multilateralized, either by becoming a provision in the WTO in the future or by being added to more and more other free trade agreements, it can become a new norm. And so when New Zealand is weighing a particular concession that's being asked of it, or a particular commitment that it is seeking from others, it's important to take into account that potential that that obligation may ultimately be broader than just the confines of that agreement. So if you're weighing the costs of giving heightened intellectual property protection, for example, in the Trans-Pacific Partnership, New Zealand shouldn't just be thinking, well, what are the implications of giving longer patent term or whatever else to those other 10 countries. You've got to ask yourselves, how likely is it that this is going to mean ultimately we're going to give this to everyone? And that needs to be factored in deciding what do you want in exchange. Because maybe the way you price it is different if you factor in the possibility that ultimately it's going to be a commitment that is going to apply more broadly. And there are both offensive and defensive sides of that. It may be that New Zealand is seeking something affirmatively that if it achieves, it can also push it in other agreements, but New Zealand's ability to be a term setter is obviously somewhat limited, whereas as a term taker, you can see that the potential is probably broader for things New Zealand agrees to being multilateralized as opposed to things New Zealand is seeking affirmatively. Okay, so we argue that New Zealand needs to be careful not to undervalue the sorts of things it's being asked to provide. Because if you just think, well, the U.S. wants this, what does that mean for us? You might not charge enough for it if you don't take into account the possibility that by virtue of the TPP members, for example, agreeing to this provision, you may effectively be making that the new international norm. So we think in terms of doing cost-benefit analysis, that needs to be taken into account. A further factor that needs to be taken into consideration in negotiating these agreements is what is it going to mean for regulatory autonomy for New Zealand? And different types of agreements may have the effect of curtailing New Zealand's regulatory autonomy more than other types of agreements. In the initial phase of this project, we looked at that issue in some detail, and I'll just summarize it briefly. But in essence, trade agreements seem to take either more of a top-down approach in which agreement is reached on sort of negative integration issues. We all agree we will not do these things. In our regulations, we will not discriminate. We will not favor domestic production, things like that. And that type of agreement, a top-down agreement, the best example is probably the WTO. So most of the commitments under the World Trade Organization are negative commitments, commitments not to have certain types of regulation. In contrast, some agreements take more of a bottom-up approach where you are negotiating positive commitments. So we will have regulations that do this, this, and this. And one example that we gave in the earlier paper was in the trans-Tasman relationship, the way New Zealand and Australia have addressed certain issues is that, to agree on commonalities in regulation, to have regulatory coherence, so that regulations are similar, makes it easier for businesses to comply if the rules are very similar in both jurisdictions. So we concluded in the earlier phase of the project that it's not as easy as saying, well, New Zealand should always go for a top-down type of agreement or should always go for a bottom-up type of agreement. Which approach is preferable may depend on the details. In the context of the WTO, the top-down approach we felt was a good approach for New Zealand because you have so many parties negotiating that even though New Zealand's quite a small player, it could join together with other countries to decide what that norm was going to be. In the bottom-up approach, it may depend. If you're having that negotiation just with the US, it may be that New Zealand doesn't have an adequate amount of say as to what those positive commitments are, but when New Zealand has negotiated with Australia, maybe it's a more favorable environment to establish what those common norms are going to be. So it's a bit context dependent. And certainly, not every agreement is going to be entirely one or entirely the other. So we characterize in this research the TPP as a top-down agreement, but in fact there are elements of it that are bottom-up. So there is a regulatory coherence chapter in the TPP, and you could characterize that piece of it as being bottom-up. So it may be the case that if you enter a trade agreement, that laws are going to have to be changed because you're agreeing to certain commitments, and those commitments may be commitments of the top-down sort where you're agreeing not to have certain types of laws, and maybe you have those laws, so you have to change them. They may be commitments of the positive sort where you have to impose certain things in your regulations, and you may need to enact new rules in order to do that. Now, it is sort of the expectation that if you're going to have regulation that you're going to do some sort of an impact assessment. But if you have a trade agreement and you agree in a broad sense, such as in the WTO, to certain provisions, at the end of the day, the agreement is going to be signed or not signed, and it may be that an impact assessment isn't conducted on each element of that package. You're agreeing to the package as a whole. And so while I'm sure there will be much discussion over the next couple of days about impact assessments and about evidence-based policy and things like that, it seems to be the case in free trade agreement negotiations that probably that isn't really going on with respect to what New Zealand is doing. And as a result, it may be that New Zealand is agreeing to certain things without actually assessing, well, what does it mean for New Zealand to take on these particular commitments? Now, certainly it may be that if you did an overall assessment of what's gained and what's lost, that you would do it anyway, but we're not quite convinced that that is, in fact, the process that is going on. So with this as background, we wanted to explore the demands that might be placed on New Zealand in different types of trade agreements, top up and bottom down, and to try to determine what does this mean for regulatory autonomy for New Zealand? What's going to give New Zealand the most flexibility? And for the top-down approach, as I said a minute ago, we're going to use the TPP as our example, acknowledging that there are aspects of it that are bottom-up. And then for the bottom-up approach, we look at the ASEAN plus context, as well as the Australia-New Zealand relationship. And what we have done is we've just taken an illustrative example to study these different sorts of models. And the example we're using is patent term extension. And if you ask really detailed questions about that, I'm punting them to Susie. But I will do my best to introduce it. And then I'm going to turn it over to Chris to talk in more detail about methodology and results. So patent term extension is where patent holders are given more time than the patent term to have exclusive rights to their patent. And why would we do this? The rationale is that sometimes there's some sort of a delay in registering a patent, or for due to regulatory requirements getting a patented product to market, and the argument is that therefore the patent holder didn't get the full benefit of their patent term and therefore is entitled to some sort of an extension. Prior to the creation of the World Trade Organization and its intellectual property agreement, TRIPS, New Zealand had a 14-year patent term and provided for patent term extension. But once TRIPS came into place, TRIPS imposed a minimum standard of 20 years for patent term. So New Zealand had to increase its patent term from 14 to 20 years. And when New Zealand did that, the view was that's sufficient to take care of any sort of delays that the patent holder might have experienced. They're getting 6 extra years, and so New Zealand stopped giving patent term extension. Australia, however, does give patent term extension, which has implications for New Zealand, obviously. It might seem that it's simple enough that New Zealand has made this decision, and its decision is it's going with the 20 years and it's not giving patent term extension. But because of all of these new trade agreement negotiations, the issue comes up again. And in the TPP, for example, the US would like all the countries to agree to patent term extension. And it complicates New Zealand's position that Australia has already agreed to that with the US and the AUSFTA. In the ASEAN Plus 6 context, patent term extension isn't being sought. None of those countries are really so keen on TRIPS Plus provisions. However, New Zealand does have some offensive interests in that context to make sure that patents are effectively enforced. So any IP that New Zealand is generating, that it's actually being adequately protected in those countries. So taking into account the fact that terms that are agreed to in the TPP or ASEAN Plus 6 may later become a broader norm, New Zealand needs to conduct an analysis of what it wants in these negotiations and of what is being asked of it to try to make sure that you're pricing things effectively and you're doing that sort of assessment. So Chris will now explain the analysis that NZIER has conducted along these lines using our example of patent term extension. Thank you.
I suppose the first thing that I want to get across to you is that for a country like New Zealand, small changes in the international trading environment have major impacts. Large countries can go along making mistakes on their trade policy and it doesn't really have an impact. But for small countries, it's very important, and that's also the case for things like high hazards. It's also the case for infrastructure. If we make mistakes, we bear them for a long time. So as I go through this, I want to make sure that you sort of think about that as an important part of the game that we're playing. So if I step back and think about what are the things that make our Christmases come at once? What are the things that they're ideal in terms of our trading if we get it right? And of course, we've already had a lecture this morning about the importance of politics, and politics is vitally important when it comes to trade policy and making agreements. If the politics is not there, then there is no agreements. We've got to, but underlying that, underlying perhaps the durability of any particular agreement, is we have to have a consensus, an internal consensus. We also have to have strong institutions which are able to implement, and the economics, it has to be coherent. And in terms of what we desire, New Zealanders, we want to be traders with the world. You know, we may be policy takers from everywhere else, but we want to be able to trade with the world, and we don't want to be able to be locked into particular blocks. We've had that once in our history. We don't want it again, because it leads to some very, very difficult choices and very sticky positions. And in terms of the style of agreement, well, we're supposed to be relatively flexible, so we should be open to whether it's a top-down or bottom-up approach. And we have to be concerned about who's joining the game, because the more the better from a New Zealand perspective. When we look at the example of patent extension, well, it's a bit of a no-brainer in terms of we're not going to gain out of patent extension. Essentially what we're going to see is revenue transfer from New Zealanders directly to the patent holder. And since we don't hold very many patents, it's a sort of a no-brainer. Pharmaceutical companies will claim that we've limited the amount of pharmaceuticals on the market, and they'll also talk about a growth in pharmaceutical R&D. We can't find much evidence for both of those arguments. The only issue here is, well, it's a bargaining chip. If we're going to give something up, and as Meredith has said, are we going to give it up to the rest of the world as well? For anybody else we want to include in these agreements, then we'll have to consider it. But the question is what are we going to gain out of a particular trade agreement? And I think that's important to understand. So when we talk about these things in terms of a framework for understanding what we can control, the stuff that we might have less control over, and the decisions about how we might interlock. And to think about this in terms of durability of outcomes. We've looked at ASEAN Plus 6 and the TPP just to think about how those agreements might run. And in particular, also important is the bottom box. You know, when we're doing these agreements with this party here, what does it mean for this party over here? And in realism terms, are these agreements Chinaable? Because that is where the growth is at the moment, and therefore we don't want to lock out of by going one way. We do not want to close off our options going the other ways. And again, that comes back to the issues about we want to be traders with the world. So in thinking about this and thinking about the nature of our agreements, I mean, we are interested in institutions in this game. Why are we interested in institutions? We're interested in them because the trade agreements look more like integration rather than tariff reduction. We're trying to integrate with the rest of the world and participate. And so the importance of institutions in that process is they are the people that implement the regulations. If the countries or jurisdictions can't implement, then we've got to make our decisions based on those issues. So the rule of law is basically a proxy for institutions. And it's a World Bank construct that we've used here, and we put in GDP per capita down the side, just to show where the countries line up. And of course, we look at the outliers. There's Myanmar and New Zealand. We're both outliers for different reasons. The fact is, if we agree to something, we will implement. Everybody knows this. Others, and this diagram shows us, well, they may or may not, depending on their institutions and depending on the way that they view these things. The one thing that's missing from this diagram is actually growth and size of the countries. The fact that China is just about on the line is important, but really it's a bulging thing because of their growth rates, and it's very important to understand that. So, and we think about ASEAN +6, and we think about, well, what are we trying to gain out of that in terms of patent extension? Well, actually, we want to make sure that the safety of the pharmaceuticals coming across our borders from these nations are at a particular level. And we're also wanting to understand, are our exports going to be, are we going to be able to protect them? So we're going to have to make some judgments about risks about those things based on the quality of the institutions in the countries that we're wanting to go to make agreements with. So on the ASEAN +6 side of things, well, it's actually quite important for some assistance to be undertaken in these regions. You know, for some of these smaller countries who have relatively nascent, I might say, institutional growth, they may be the same as China, but everybody's diving into China because that's where the growth is. So that's why they miss out. Not because of the size of their institutions, but because the bigger markets are in China. And that's why so we've got to think about that. Countries perhaps like Indonesia and Vietnam, which are bigger, they may have less a problem than countries like Laos, Myanmar, and even countries above the line, such as the Philippines. So, but from a TPP perspective, we're looking for something else in this game. And it's essentially, in terms of patent extension, there's a limited upside. So the question about the TPP is, who else is joining the game? And will others be able to join the game? So in that respect, I think, for example, the accession of Japan is actually quite important. It's going to slow the whole process down. There's no question about that. But the Americans, for example, may be looking for agricultural liberalisation in Japan. And that's something we may be able to piggyback on. So our choices, I think, with the Japanese and even with the Canadians joining, they may have multiplied. So that's an important part of the process. And again, in all of these things, will the Chinese actually join these things? In the ASEAN context, we've gone through the ASEAN plus one agreements. We've taken a bit of a breath in between those, basically because they were quite torturous. In particular, one country was extremely difficult to deal with, and ASEAN has sort of said, well, if we're going to move on, we're going to have to have a better, a smoother transition. So, what does this mean for New Zealand? And I think I sort of think about these things when I typify sort of a hard agreement here. I'm really talking about things which we're going to get some short-term pain, and perhaps we may get some long-term gain, although it's hard to say. I mean, for example, in our trade policy history, the signing of the New Zealand-Australia Free Trade Agreement in 1965 was an extremely hard agreement because it didn't allow consumers to actually gain or benefit from that process. And we signed that agreement, and it went on and on and on, and in the end, it was the Australians who tore it up and threw it away, not us. So the point about this is, I suppose, on the soft side, we're more interested in that. And the question that I sort of pose is, well, have we moved from the TPP, for example, from a potentially hard agreement into a potentially soft agreement with the Japanese joining? And that shows an important point for us is here, we want other people to join these agreements. So therefore, the ability for others to join up with these types of agreements increases the game for us. And I think, and I've got to say, it's some relief that I've seen the Japanese join. Basically because I was finding it struggling very hard to see what we were actually going to gain from the TPP in its narrow context that it was being played in. So, in terms of our conclusion, it is about integration. It's not going to be seamless. It is tiny steps on a long road. Institution building in this game is a hard business. To bring some of these countries along, to actually gain the benefits that we think we might get out of these agreements is actually, it's going to take a long term. And it is a tangled web. And we're going to have to straighten out some of those webs. We are outside of our comfort zone because we are used to doing agreements which bring down tariffs. We have not been involved in these behind-the-border negotiations, only really with Australia in this game. And that's taken a long time. So to actually project what we've done in the CER, and we want to go further in CER, into Asia is going to be very difficult. It will rely on us doing our own homework in this game, understanding what the costs and benefits of these things are. And it will require more resources. Because the key goal here is durability of an agreement. And to get it right at the beginning is also important. Because you can't change once the agreement's really put in place, particularly if you're dealing with larger countries. In terms of patents, well, we're looking for a different assurance game. From the TPP, we're looking for, well, what else are we going to get out of this? And in the end, it's really about how can we extend these agreements, whether it be ASEAN +6 or TPP. We've got to make sure that we can move on, read China, read even the US-EU trade agreement. Thank you very much.
Well, to begin with, I'd like to pay tribute to Fiona's keynote, which beautifully set the scene for all of the things that over a couple of years I've been grappling with this topic. Regulating foreign direct investment in New Zealand has levels of the never again debate, of people who want less regulation, of people who want more regulation, of people who want a scientific, technical view, of people who see only the political dimension, of those who want to keep the economy going, and of those who want to make people feel safe, of arguments that on all sides of the debate are viewed as rational and irrational, and all in all, it's a pretty thankless task for someone who's actually, as I am, a commercial litigator. So I'm someone who puts my hands up at the beginning to say that I'm one of the people Susie identified as really being invited to step outside my comfort zone with this topic. And as you'll see in this short presentation, I've stepped quite considerably outside it because of the way that I thought thinking about this topic needed to be tackled. If you were a Martian landing in Auckland in 2013, or probably 2012 might be a bit more accurate, and you were asked, what are people talking about when they talk about foreign direct investment, you'd say that what they are debating are issues of land ownership and Chinese investment. And if you had been that Martian landing in Auckland more than a century ago, you would have thought that what they were talking about was a debate about land ownership and British investment. And I've put a quote here from Premier John Ballance, which I'll read out because I very much love this quote. "I care not if dozens of large landowners leave the country, for the prosperity of this country does not depend on this class. It depends on ourselves, upon the rise of our industries, and upon markets being secured in other countries, and not upon such fictitious things as whether the large capitalists remain or leave the country. It's us against the world." That's at least one view to have, and that's a view that has remained central to what people think they're talking about when they talk about foreign direct investment. It took me really until I wrote 2 papers on this, really until the second paper that I wrote to get my head around why this really was so intractable. And that third bullet point, the Richard Boast book, really helped me understand why land is so critical to the New Zealand debate. Every country fights over, or internally over, how they will approach foreign direct investment and whether it's a good thing or a bad thing, and which bits of it might be good or bad. But the land dimension is a peculiarly front and centre issue for New Zealand. And what that book does, and I'm vastly oversimplifying Richard's thesis, and I hope you'll forgive me, but what it does is it explains the different importance of land to both the Maori indigenous population and the Pākehā settlers. To the Maori indigenous population, we're all familiar with the spiritual and cultural importance of the land. To the Pākehā settlers, what his book does, it was bring into play in a way I hadn't previously understood the moral dimension that many of those settlers had towards clearing and developing land and turning it into farmland. You can see it as a sort of workout of the Protestant work ethic. But it was really important for the people who came to get their 5-acre block, show that they had wrought their powers upon the land, and to show that they had something to show at the end of it. And we see these things in tension in lots of New Zealand regulatory contexts, but few as much as who gets to own land. And one of the interesting things about the FDI debate is that it's one of the few areas where both of these forces are on the same side. You give people a common enemy and they can unite. So instead of the foreshore and seabed debate where those forces were opposed, when you talk about Chinese investors coming to own the land, the one thing that many people can agree is that they shouldn't, or that there need to be regulations, or that the government has to stop them. In the next bullet point down, I've made a reference to the Overseas Investment Regulations 28H I&J. I'm not meaning to make this a technocratic presentation, but it's important to understand a little bit of background about the Overseas Investment Act. So we had a 1973 Overseas Investment Act that basically made it relatively bureaucratic to invest in New Zealand. Many things needed to be reviewed and looked at, although New Zealand's always had quite a high degree of foreign direct investment. In 2005, the Labour government abolished that act, put a new act in place, which was designed to focus investment screening on what really matters. And what really mattered was effectively investments in sensitive land. And sensitive land was defined as the foreshore and seabed, land adjoining lakes and rivers, and any rural block of more than 5 hectares. And the idea with this regime is that if you were investing in that sort of sensitive land, you had to pass 2 hurdles. You had to pass an investor test, you had to be of good character and have sufficient business acumen, and you also had to pass an investment-centric test, that the benefit that you would bring as an investor was in some way something that would outweigh the benefit that would have existed otherwise. And there's a wonderful Henry VIII clause in the Act, in section 17G of the Act, that says that in applying this test, the Minister is bound to apply all of the criteria in this section 17, plus subsection G, anything that is set out as another criteria in applicable regulations. And this has been a wonderful political tool. So through the Overseas Investment Regulations and Regulation 28, the government, whenever it is in political difficulty, can add a new regulation to the test that needs to be applied. And it can do that even while the test is being applied to a particular regulation in order to make sure that it is dealing with political issues in a way that matches its political fortunes, or at least as it hopes they will be. So when the Canadian Pension Fund wanted to purchase Auckland International Airport, Regulation 28H was inserted by the Labour government. But in 2010, when Chinese investment in farmland became more topical, regulations I and J were inserted by the national government. And so it goes on. If we look at the Crayfar farm saga that everyone will be familiar with, we've had two court decisions on that. We've had a decision in February 2012 by the High Court and a decision in August last year by the Court of Appeal, each one looking at the intricacies of how this test works. So the High Court decided on, under much pressure as to how this counterfactual test is to be applied, that it should be applied on what's called a with-without basis. So instead of saying, is New Zealand going to be better off with this foreign investment than before the foreign investment was made, you have to say, is New Zealand going to be better off with the foreign investment than without the foreign investment? And therefore, the decision on Shanghai Pension making its bid needed to be remade, and it was repassed. And then the Court of Appeal looked at whether the expertise that the Chinese owners had counted, because they weren't dairy farmers, they were actually commercial property developers. And the Court of Appeal said that their general business expertise was basically good enough. And so what you can see here is that I could have given this presentation and written both of my papers on the intricacies of the Overseas Investment Act. That's what most lawyers would have done. That would have been more within my comfort zone, although that's not actually my area of practice as such, and I could have sort of fended off any bigger questions there. But from quite early on in this process, I realised that this whole debate was actually an application of my favourite literary term that I remember from secondary school, synecdoche. Synecdoche is the figure of speech for where you use a part to mean the whole, as in where you describe your car as your wheels or something like that. And it really struck me that this debate about how we apply the Overseas Investment Act and which regulations we want to change in one direction or which ones we want to change in another are allowing us to myopically see a part of the debate about what we do with foreign direct investment, but not really look at the whole. And the reason for that synecdoche, for that myopia, is political. This is a wonderful political lever. It's in a political interest to focus all issues about foreign direct investment into this area. It's very politically charged, and it is actually something that many people instinctively also want to talk about only when they talk about foreign direct investment. So don't get me wrong, it's an important part of the debate, but like all synecdoche, it's a part of the debate, and it's not the whole of the debate. And what frustrated me in trying to put the paper together was that there was very little written out there on how New Zealand should approach the whole of the debate. So, I wrote a first paper, and at the end of that paper I asked 3 questions, which I hoped would be able to be answered during the course of the second paper. And those 3 questions were, what economic contribution does New Zealand require from foreign direct investment? Number 2, what direct restrictions on foreign direct investment, if any, are desirable? And number 3, what direct incentives for foreign direct investment, if any, are desirable? And it was interesting that those questions, particularly the first one, proved very hard to answer. But first, just 2 short diagrams to illustrate the synecdoche type point. One of the things that became clear when I thought more about foreign direct investment is that if you just plot on one axis what you can do to foreign direct investment on a scale from forbidding it to incentivizing it and all the steps in between, and on another axis you plot how much influence the government actually has, it strikes me that there is a lot of power when you want to say no. When you don't want particular investment in your country, but that investment would otherwise have come, you've got governmental power. That's something the government can do something about. And that's why I think a lot of the political debate is about forbidding, restricting, screening investment, because you can just pass a law. You'll do something about it. But of course, there's a whole range of other things that you can do. It's not obvious that they're all going to work. You can permit investment. New Zealand could permit Wellington to be turned into the Silicon Valley, but that doesn't mean that it's going to happen. You can welcome it. You can go out and talk to people in the Silicon Valley and try and persuade them through investment promotion arms to come and invest here. But that doesn't necessarily mean it's going to happen either. Or you can incentivize it. You can actually try and put programs in place to encourage certain investments to come. Well, that doesn't mean it's going to happen either, but it might help it, which is why the line goes up, but it's going to cost money. And free marketeers have a problem with incentives because they distort markets. If you look at the distribution of New Zealand's foreign direct investment policy along that same axis, you can see that we don't forbid anything. We don't really restrict anything. We do screen some types of investment in fisheries, forestry and agriculture where they're about sensitive land. We don't screen, for instance, mining investments by foreign ownership, although we do have a owner-neutral regulatory regime for them, and that's the same for media, banking, manufacturing. And we welcome particular types of technology investments, and we incentivize in the film industry and somewhat in the venture capital industry. And it's interesting what distortions you do see from some of this. So, for instance, if we look at what we screen, and we think back to the Canadian Pension Fund acquisition bid for the Auckland Airport, you can see that the only reason that was screened is because Auckland Airport happens to adjoin the Manukau Harbour, and so it sits on sensitive land. If it hadn't sat on sensitive land, then no matter what new regulations the government made, it wouldn't have been able to be reviewed, even though one of the regulations they did make was that in deciding to let foreigners buy sensitive land, you should consider the strategic interest of New Zealand in owning that sensitive land. But we don't have airport owner regulation, we have airport use regulation. So, when I tried to put all of this together, what I came up with, at least for the purposes of this presentation, to get the discussion going, were really 5 themes that struck me as interesting. One is that I think a consequence of synecdoche in this area is that one tends to see the trees and not the wood, and then to leap into those trees at every available opportunity. So that's what I call tactics versus strategy. We have a lot of vexed debate. You could fill up a conference room just talking about what we should do with the Overseas Investment Act and whether we should add a new criteria to Regulation 28 or whether we shouldn't, and how the existing criteria are worded or not. But there's not that much talk about what it is we really want out of foreign direct investment. What are we using it for? What's the value of it for us? And I think that this focus on tactics and not strategy has some effect on other debates. I went on a quick hunt for articles criticising the government on the Sky City and the Hobbit incentive deals that it offered. Peter Dunn sent a time bomb warning to John Key last month, saying support for his cut-through approach on offering incentives to build the Sky City Convention Centre in Auckland will wither if it's seen to be a standard proxy for bending the rules or doing special deals to achieve the desired outcome. Well, it's partly because we don't have any policy, let alone framework, on when we offer incentives to have foreigners invest in infrastructure in New Zealand, and we don't have any democratic insight into that process or input into that process, and we don't have any review or even a retrospective cost-benefit that's public for that sort of process. So what we have instead are sweetheart deals, and the Hobbit deal was seen as another one of them. We had a particular foreign investor that we wanted. We don't have a strategy, but we do have good tactics, and the government's tactics were effective in both cases. So first thought that I had is that we could do ourselves a favour by trying to lift our sights a bit, stop thinking about tactically how to win a particular battle, start thinking about how we might want to win the war, if you can even define what winning would mean and agree on what war we're fighting. Second issue is untangling the land debate. Seems very clear to me, looking at the Crayfar Farms saga, that the issue of foreign ownership of New Zealand farmland is a political stumbling block. It sucks the oxygen out of this debate every time. It makes it very hard to go into any of the more nuanced and quite important questions that New Zealand needs to answer. And so some political leadership on getting past this issue to look at all of the other things that need to be looked at seems important to me. In my paper, I argued that the ideal solution would be to reframe what it is people are concerned about in the land debate. And this may be provocative, but it strikes me that a lot of the concerns that are expressed could be reinterpreted not as concerns about Chinese ownership as such, but as concerns about corporatization, about massive land aggregation, and about vertical integration. It's not obvious to me that a Chinese-owned consortium for the Crayfar Farms block is any worse for New Zealand than a Michael Fay-owned consortium for the Crayfar Farms block, yet it was the Fay bid that took both of the cases to the High Court and the Court of Appeal. But I do, as I did in the second paper, set out a couple of ways in which, if New Zealand really can't get over this debate any other way, it could perhaps forbid the sale of farmland to foreigners but permit economic rents to be transferred. And that's what we do with forestry rights, for instance, and they're registered in our land transfer system. So there are ways to try and get beyond that debate, but I think it needs to be done. Third thing is, I think New Zealand does not think deeply enough about regulatory techniques beyond legislative fiat, where you can't say no to something, but you have to find ways to say yes, or to say please, or to say, why don't you come over here? That doesn't work so well. We don't have much of a debate, we don't have much sophistication, and yet we probably need it. Fourth point is, I was stunned by the lack of clear data in this area. I saw a lack of data when I did the paper myself. I saw a lack of data when I got NZIER to help me. We really are dealing in a space here where the political the politicisation's really come to fill a gap in data. No one really knows what FDI is good or bad, and so there's a need to deal with that limited data, which may well involve some form of experimentation. So, in a nutshell, and trying to use the approach of keeping the status quo but picking out the bad bits, I thought that if you think the point of FDI is that we should let it in to the extent it contributes to GDP or encourage it to that extent, then the future for New Zealand's clearly in closer economic ties with Asia. So framing the FDI debate as really one about Asian integration seems to be a good idea to me. That's what Australia's done with its white paper. That's what New Zealand's China strategy is sort of about, trying to think about moving into value chains, improving connectivity, and using FDI to increase New Zealanders' ODI, overseas direct investment, seems to be a good idea. And then the last three bullet points are really saying that all of the technical evidence I looked at tells me that we don't have a problem of not enough foreign direct investment in the country. So if you're a foreigner, you have to come here and invest. What we have is a problem of not sufficient labour productivity, which means we're not getting what they call spillovers. And spillovers is this magic word in foreign direct investment language, which means synergies that come from all of the good stuff that superior management, fresh ideas, better resources, better connections that foreigners may have can give to us. And I'm sure we can all think of examples. So to conclude, one of the ways that I rationalise this together is that if you think that's the strategy, then you might have different techniques for different situations. So I've got two dimensions here. One is, have we got a competitive advantage in this area? And the other is it exportable or not? So if you look at the first square, where we have a competitive advantage and our product is exportable, like the production of our dairy farms, then I think there's a good case that we should generally regulate to extract spillover benefits, because people will come anyway, so why not make them sign on the dotted line to give us something that we want. Where we've got no competitive advantage, but it is an exportable industry, then we should be seeking to extract spillover benefits through other regulatory techniques. Where we've got no competitive advantage and it's not exportable, well, then we just want the FTI because we don't have enough money. That's like building the Sky City Convention Centre. Then you just make a decision on the case, but it's not so important to have it tied into a theory. And where we've got a competitive advantage, but it's not exportable, that's like our New Zealand power companies, then I don't think FDI is actually all that important or not. And therefore, it's not obvious why, if we sell New Zealand's power companies, foreigners as opposed to nationals need to buy them. So, two concluding thoughts here. One is on the prohibitive side of the spectrum, on things that we're going to stop happening. I think regulatory stability has some real value, and that requires political courage, skill, and a certain amount of self-restraint, and I don't think there's any evidence that that is really in existence at the moment. On the permissive side of the spectrum, I think what has got a premium is regulatory flexibility and creativity, and that requires risk and experimentation. I said in my paper rather provocatively that I think here New Zealand should try and think rather more like scientists and less like economists. More about not trying to build a big theory at the outset, but just experimenting, just seeing what works. You might find you grow a film industry overnight with an incentive program, and look, that's basically what we did. Thanks.